Question is that the bill be now read a second time. As many as of the opinion say aye. Oh, sorry. Mistake. So then it's done.
Thank you, Mr. Speaker. I first declare my interest as a shipping lawyer. Mr. Speaker, the main thrust of today's company's amendment provides that the ship owner's lien for bill of lading freight, sub-freights, sub-hires, or for any amount due under any charter no longer requires registration under Section 131 of the Companies Act. Under the proposed amendments, a ship owner includes a registered owner, a disponent owner, or a bareboat charterer of a ship. Simply put, the ship owner can intercept income due to charterers in the form of bill of lading freight, sub-freight under a voyage charter, or sub-hire under a sub-charter. Today's bill for the proposed amendment of Section 131 of the Companies Act stems from the recent Court of Appeal case of Diablo Fortune and Duncan Lindsay. The Court of Appeal, with 5 judges hearing the appeal, affirmed the decision of Judicial Commissioner Audrey Lim in the High Court below. Diablo Fortune, Inc. are the owners of cargo vessel V8 Stealth II. They bareboat chartered the vessel to Seva Ships International Private Limited. The charterers enter into a pooling agreement with another company by which the charterers earn charter hire. The charterers then went into liquidation and the owners sought to enforce a lien over sub-hire pursuant to Clause 18 of the bareboat charter party by serving a lien on the pool. The pool withheld hire payments to the charterer. The liquidators then applied to the High Court directing payment of the charter hire to the charterer. In the High Court decision below, the Honourable Judicial Commissioner held that the lien over sub-hire created by a charter party was registrable pursuant to Section 1313F of the Companies Act as a book debt or pursuant to Section 131G as a floating charge. This decision in July 2017 last year generated a strong reaction from the maritime community in Singapore. Although it can be said that the decisions of the Court of Appeal and the High Court are not surprising, given that they are in some respects consistent with English law on the registrability of liens on sub-hire and sub-freights, the recent decisions are nonetheless the first local judicial pronouncements on the effect of non-registration of such liens. The shipping community, led by the Singapore Shipping Association, bemoaned the onerous and administrative burden of having to register all such liens and pleaded for a statutory carve-out. This reaction from the shipping community is perhaps hardly surprising, at least to those in the community, and I'm in total agreement. Such a lien clause is very common in standard charter parties all over the world, not just in bareboat charter parties, which is the subject of the Diablo case, but also in time or even voyage charter parties. In many of these commonly used charter party forms, we will use a variant of a lien clause allowing lien over hire, freight, sub-freights, or sub-hire. Parties all over the world enter into charter parties on an everyday basis. Singapore is, of course, a major maritime hub in the world, with many shipping businesses setting up companies, subsidiaries, and operations in Singapore. Moreover, many charter parties and fixture notes have Singapore or Singapore law as part of their jurisdiction, or arbitration, or governing law clauses. I agree that it's wholly impractical to require all liens for freights, hire, sub-freights, or sub-hire to be registered as charges under Section 131F or G of the Companies Act. If the law is not amended, businesses may be compelled to register charges for such liens, and failure to do so may even lead to penalties under the Companies Act. Besides being impractical, it is inconvenient, and perhaps the legal fees for registrations are unnecessary expenses for businesses. Notwithstanding the recent judicial pronouncements of there being a need to register a charge under Section 1313F or G, the reality is that the practice of registering was never part of our commercial landscape in Singapore. It is notable that the Court of Appeal made comparisons with the corresponding laws in the UK and Hong Kong respectively. I would suggest that the comparisons with UK and Hong Kong are not merely of jurisprudential significance. Whether as Admiralty jurisdictions, legal or maritime centres, England and Hong Kong are arguably two of Singapore's closest rivals. While it may be a slight exaggeration to say that maintaining status quo will put Singapore in a distinct disadvantage compared to Hong Kong, it is important that we continue to make our maritime and legal hub as competitive as possible and minimize or avoid any unnecessary shortfalls that make us less sensitive to the needs and the views of the business community. The amendments should now place our law on ship owners lien in a better position than Hong Kong or the UK. The proposed amendments under this amendment bill are also timely in that Singapore is aiming to be one of the leading international debt restructuring centers in Asia, especially with the amendments to the Companies Act provisions brought in May 2017 with the introduction of the UNCITRAL model law on cross-border insolvency. In recent years, insolvency cases involving internationally well-known companies have been started or filed in our courts for various reasons, such as insolvency protection and debt restructuring. They include companies in shipping or oil and offshore industries too. The proposed amendments will bring about some certainty to the interpretation of Section 131F and G of the Companies Act, while the amendments themselves will not, in my view, necessarily put any party in a position of great disadvantage. Mr. Speaker, for the above reason, I support this amendment bill. The Court of Appeal was certainly right to recommend the proposed changes to Parliament.